Good. You're seeing it now?
Yes.
Great. And I'm going to make it bigger.
There you go.
Okay. So, as part of my argument against the Supreme Court, I'm going to be talking mostly about the Supreme Court's role in terms of property and privilege in our country. And the reason why is for the following. Whenever I have discussions about the Supreme Court and about judicial review and the federal court system in general, these are the things that are usually, and not literally these professors in their quotes, but these are the types of arguments that are made. We have to have judicial review because it not only will prevent big government oppression, but particularly, and who could argue against this, it will protect minorities. A guarantee of individual and minority group rights. So the traditional way that people understand the court and its role, or the courts and their role in American society when it comes to judicial review, is without them, we wouldn't have the protection of groups that are marginal or marginalized. We wouldn't have the end of Jim Crow. We wouldn't have the laws regarding, or the prohibition about laws that prevent gay marriage. I could go on and on in terms of all the rights, the criminal rights, and so on and so forth, that the court has enacted for us by its decisions. And I'm not questioning that that has happened on occasion, but really that's been a rare occurrence in terms of Supreme Court history. Usually the court has not acted on behalf of oppressed minorities. Usually the court has acted in defense of powerful interest, and particularly property interests. And that might be a good thing. I, of all people, am not going to deny that it's wonderful that the court protects property. And just making the argument that the traditional way in which people understand the court is really turning on its head what the court has usually done. And I'm going to start with one of the most bizarre decisions in a long history of odd decisions when it comes to reasoning. And that is the slaughterhouse cases. And as far as the slaughterhouse cases are concerned, it's important to go a little bit into the history of the 14th Amendment. You know, in the past week, I've been in touch with a few of you, and even seen a few of you. And Alex Rabinowitz, shout out to you. I think it was one of the things that you posted in chat was a comment regarding the 14th Amendment, or these Civil War amendments, or Reconstruction amendments would be more accurate, the 13th, 14th, and 15th Amendment, which really gave us a new constitution. Or at least they were supposed to give us a new constitution. And in particular, the 14th Amendment is an amendment which overturned much of what had been embedded in the initial constitutional efforts. So let's take a look at the 14th Amendment, or at least a portion of the 14th Amendment. I want to hide your faces because it's getting in the way a little bit of the quote. But this is the key section which I'm going to be focusing on for the purposes of talking about the slaughterhouse cases. First part doesn't really impact so much. All persons born and naturalized in the United States, we're going to leave that aside. But this is the key part. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdictions the equal protection of the law. So, since the courts engage in interpretation, the question arises, what the hell does this mouthful mean? What actually is going on there? And I think that if one's going to try to understand what a law is, I think it's important to, and there are different opinions about this, about how to go about it. But for me, the proper way to go about it is probably to go back to of all things, coming from this liberal, go back to original intent. Try to understand what the legislatures meant when they wrote this into the amendment, which they had proposed and which then got ratified. And let's take a look at what it meant to the man who wrote the amendment. Now, before I tell you what Congressman Bingham meant or said he meant, how he understood his own words, investigations have been done, studies have been done, in large part for the purposes of trying to help the court understand what the 14th Amendment meant. And one of the most important studies was done by Fairman, who claimed that the 14th Amendment could not have overturned the Constitution, that the 14th Amendment did not, and I'll explain the term in a moment for those who have not heard it, did not incorporate the Bill of Rights into the state constitutions, because that's really what the big argument about the 14th Amendment is. Did it incorporate the Bill of Rights? So let's backtrack a little bit more now and talk about the Bill of Rights. The Bill of Rights, and this is going to sound like a really odd comparison, is a little bit like the Immaculate Conception. When I ask the average person, and actually the more intelligent than average person, about the Bill of Rights, I never get the right, I rarely ever get the right answer. And I'll tell you what I mean by that in a moment. Why the comparison to the Immaculate Conception? Because I've rarely ever met a Christian who knows what the Immaculate Conception is. So to my Jewish audience, I'm going to take a moment and throw this out. What is the Immaculate Conception? Somebody dare answer.
Is it the notion that Jesus was conceived without sex?
We're going to have
And
to,
that God is the Father.
and that
No,
God is the Father.
I thought that it was that Mary actually was born without.
That's
sex.
it.
Yes, it's
That's
Mary. It's Mary.
It's Mary's, but it has nothing to do with Jesus except indirectly. It's that because we're all born according to the Christian doctrine with original sin, how could the Godhead be born to a human being without original sin? How could a God be born to a human being? And it's because Mary was born without original sin. So, you know, and I've asked this, I've rarely ever gotten anybody who knows the answer. And by the way, embarrassingly to them, including priests, which is astonishing to me. Now, back to the Bill of Rights. So, you know, I asked the question of people, under the original Constitution, could a state have established Judaism as the religion of that state? Lord knows that they wouldn't have wanted to, but still, could they have? Or could a state throw you into jail for printed words in a newspaper? And so on and so forth. And of course, you know, I always get the answer. I wouldn't be discussing this if I got the right answer. I always get the answer. Of course, states couldn't do that. The Bill of Rights prevents it. The Bill of Rights gives us freedom of speech, so on and so forth. But again, I'll throw this out. How come the Bill of Rights didn't stop states from doing those things?
Because Congress shall make no laws.
Right. Congress shall make no laws. Exactly. And so if a state was making that law, then it's not the Congress making that law. So most of the things in the Bill of Rights were not binding on the states. And that was the subject of some debate, you know, when they were being drawn up and when they were being ratified, but they were not binding on the states. So along comes the 14th Amendment, and the 14th Amendment, those words of the 14th Amendment, supposedly, that's at least what was a widespread feeling, had now placed the requirement on the states that they had to abide by the Bill of Rights. From the moment the 14th Amendment was ratified, it meant that states had to protect and not attack or violate the precious rights that were contained within the Bill of Rights. In other words, they incorporated the Bill of Rights into the state obligations, the state actions, and it's called the doctrine of incorporation. But in the 1940s, 1950s, and actually even earlier, the court was acting as if the 14th Amendment did not do such thing, and they were interested in whether or not the 14th Amendment actually was meant to do such a thing. And Fairman, in his study of the congressional debates and the statements made by the people who authored it and who adopted it, came to the conclusion that indeed the 14th Amendment did not incorporate the Bill of Rights into the state constitutions. And his argument is the following, and let's take a look at it. He said Bingham, pictured here, had muddled thinking. So therefore, when Bingham said things which seemed to indicate that the Bill of Rights was incorporated, that can't be true because Bingham was muddled. Do I need to deal with the fallacy of that argument? Just because Bingham was muddled does not mean that he meant his words, which we're going to look at in a moment. Bingham was singular. In other words, Bingham was not like other congressmen and other people at that time who argued that the Bill of Rights was not being incorporated. But the reality was that Bingham was not so singular. And the third argument that Fairman made is that the Bill of Rights could not have been meant to have been incorporated, because if it had been incorporated, it conflicted with so many existing practices of the states that when the 14th Amendment was ratified, in the state conventions that were held, the state legislative debates, I mean, that were held, certainly people would have mentioned that. A state that, for example, did not abide by the Bill of Rights requirements regarding juries, that would have come up. People would have said, does that mean we have to abandon our system and adopt this system? Are they telling us what we can and cannot do about juries? And therefore, Bingham could not possibly have meant the Bill of Rights to have meant to do that, because certainly he would have been aware that this would create great chaos, great opposition, and it never could have been ratified. And the problem with that argument is that Bingham is a national congressman, and it's entirely possible that he wrote largely wrote the amendment without having any idea that there were those more obscure existing practices. Just because he was ignorant did not mean that he wrote the bill to mean something quite different. And let's just take a quick look at his words. No state may deprive any citizen of the rights and privileges of a citizen of the United States within the limits of that state. The 14th Amendment secures this power to Congress, that the United States to deprive any citizen of the United States of the rights and privileges, that the Congress has the right to prevent states from doing it. I'm paraphrasing there. The amendment gave Congress the express power to enforce the rights which were guaranteed, referring to the Bill of Rights. The 14th Amendment would arm Congress with the power to enforce the Bill of Rights as it stands in the Constitution today. Is there anybody who thinks that there's anything unambiguous about those words? Speak up now or hold your peace. I think that it's perfectly obvious what Bingham meant. He meant that given the circumstances in which Southern states were violently repressing the newly freed citizens, Black citizens, the former slaves, that the Ku Klux Klan was terrorizing them, that the 14th Amendment was meant to put a stop to that, and in particular, the enforcement mechanism in the last clause of the 14th Amendment. Congress has the power to enforce these clauses, particularly this was meant to stop those violent practices, those terroristic practices. I don't think anything could be clearer. And indeed, there were a number of early court decisions right after the ratification which more or less recognize that. But then along comes the slaughterhouse cases. And I don't have to go into much detail about the actual case, the background of the case. New Orleans was a filthy place. The slaughterhouses were horrible pollutants. The New Orleans, or Louisiana, actually passed a measure, a law that created a single large slaughterhouse in the outskirts of the city, and all slaughtering for the city had to take place there. If you were a slaughterhouse proprietor running a business somewhere else, and you wanted to continue the practice, your business, you had to engage in the slaughtering. You'd have to pay a small fee to the, or fee, I don't know how small it was, to the central slaughterhouse monopoly, and then you could engage in your business there. So a number of the slaughterhouses in New Orleans sued, claiming that the slaughterhouse laws abridged their privileges and immunities as citizens of the United States. It denied them equal protection of the law. It deprived them of their property without due process of the law. The 14th Amendment, they claimed, applied to them and their businesses, meant that this ordinance, this law, had to be declared unconstitutional. So let's see what the court did with it. So I'm going to go over this first part very, very carefully. It's quite dense. The distinction between the citizenship of the United States, this is the court majority, and the citizenship of a state is clearly recognized and established. Not only may a man be a citizen of the United States without being a citizen of the state, but an important element is necessary to convert the former into the latter. All right, so there are two types of citizens in the United States, according to the ruling. You have a dual capacity, a dual identity as a citizen of the state and as a citizen of the United States. All right, so far, somewhat unobjectionable. It is clear then that there is a citizenship of the United States, citizenship of the state, distinct from each other and which depend on different characteristics or circumstances of that individual. Okay, so what is the conclusion from that? So the conclusion from that is that the Bill of Rights, or I should say the 14th Amendment, only prevents a state from violating the particular rights or privileges and immunities that you have as a citizen of the United States. That if there are specific types of rights, maybe additional rights that you have as a citizen of a state, that's a separate thing. If you have fewer rights that are not necessarily connected to United States rights in a state, that's a separate thing. The 14th Amendment, according to this ruling, only prevents a state from violating your privileges and immunities as a United States citizen. So then the issue is what are your privileges and immunities as a United States citizen? Now, if you go back to the words of Bingham, the privileges and immunities that you have as a United States citizen include whatever privileges and immunities you have from the Constitution as originally written, plus the privileges and immunities created by the Bill of Rights. That's Bingham's own words. That's Bingham's intent. That was the intent of most of the members of Congress. All right, so let's see what the court now does. So first it goes back to the Articles of Confederation to see where privileges and immunities are defined. And in the Articles of Confederation, it says, connected to privileges and immunities, that the people of each state shall have the right to ingress and regress, to travel to and from any other state. They shall have the privileges of commerce, trade, subject to the same duty, so on and so forth. All right, so that's history. Privileges and immunities is that. Then it comes to what the Constitution establishes. So what does the Constitution say? The Constitution has a mention in the core original Constitution of specific rights that you have. Let's leave aside the Bill of Rights for a moment. To come to the seat of the government to assert any claim to engage in administering its functions, to share its offices, the right of free access to seaports. You also have the privilege of being protected from piracy on the high seas. Big, important stuff. So just talking about this part, the 14th Amendment, according to the majority's decision, certainly meant that a state that did not allow you to travel into that state or to have the free access to its seaports if you were a U.S. citizen or just a state citizen was violating that portion of the Constitution. If a state did not do anything within its capacity to protect you from pirates, then the state was not abiding by the 14th Amendment. All right, none of that has anything to do with the issue that the slaughterhouse owners were bringing up. They were talking about bigger stuff, due process of law and their property being taken away without due process, being discriminated against because a monopoly was being created. So what does the Bill of Rights have to do then with that claim? Does the Bill of Rights apply to that claim? And if so, does the Bill of Rights protect the slaughterhouse owners? And what the court said, and I'm going to go very slowly on this, is no, the Bill of Rights really doesn't apply. And let's just take a specific example. Let's say, even after the 14th Amendment was written, that a state government threw you into jail because you engaged in some speech which it disapproved of. Why would that not violate the 14th Amendment? Why could a state have a law that said you cannot practice as a Jew in the state of Louisiana, even after the 14th Amendment? Figure it out. How could a state, when the 14th Amendment clearly says, as one of the precious US rights, that Congress cannot establish a religion, prevent you from the free exercise of your religion. How could this court in this decision essentially adopt a position that a state could still prevent the free exercise of religion if that's a United States right? Anyone have an answer? And particularly our lawyers. I feel like I'm going to sit here a long time. The First Amendment clearly states Congress cannot do those things. How come after the 14th Amendment, a state could still do it?
Why would the 14th Amendment necessarily incorporate the Bill of Rights themselves so as to apply them all to the states?
Well, because that's what the people who drew it up said it did. That's why.
Right. Wow.
That's literally what they said it did. So how come the court could argue that, leave aside the fact that, you know, forget about Bingham's words. What's their argument that when a state, let's say, if a state threw you into jail for your speech, had a law that prohibited certain type of speech, why, according to the very fine reading of the 14th Amendment and the Bill of Rights, could they claim they had not violated? If free speech is your US right, how could they still suppress your free speech? Well, here's the answer. Because what does the Bill of Rights say cannot suppress your free speech? Congress. Comes back to Congress again. So therefore, that's a very precious right. When a state suppresses your free speech, it's not the Congress doing it. So therefore, a state could still do it. Now, forget about the fact that Bingham, when he wrote these words in the 14th Amendment, meant that what Congress could not do, states could now not do. What the Supreme Court chose to do was to ignore the intent, ignore the clear meaning of the words of the 14th Amendment, and to adopt a Jesuitical position in which they were being very, very, very precise to achieve a very, very different goal from the 14th Amendment. That is, they're saying, oh, we're completely abiding by the words of the 14th Amendment. When a state government acts against your free speech or your freedom of religion or freedom of the press, it's not the Congress that's doing so. The state is not Congress, and therefore the 14th Amendment does not incorporate the Bill of Rights in effect. I mean, it does in a way, but reading it in a way that means it doesn't. It completely reverses the actual 14th Amendment. And it's an amazing decision demonstrating how a court intent upon achieving its own ideology can not only subvert, but completely turn upside down a congressional initiated action. And it has enormous significance because once you don't incorporate the 14th Amendment, the actual things that the 14th Amendment was supposed to achieve, which is to protect the free men and their descendants from violent repression, is now, as far as the court is concerned, not the business of the court. The court does not have to make states protect the citizens' equal rights. So you get decisions like Williams v. Mississippi. Williams v. Mississippi involves somebody who was, I think he was on death row for murder, and he claimed that the jury trial he had was actually unconstitutional because it was made up of Mississippi voters, and Mississippi voters were almost all white because under the Mississippi laws of poll taxes, literacy tests, and the way they were administered, the free men, the African Americans, were basically disenfranchised. A clear violation of the 15th and the 14th Amendment, in my opinion. But the court ruled that the laws of the literacy tests and poll taxes were colorblind. It didn't matter that they were drawn up specifically to prevent blacks from voting. They never mentioned that the intention was to do that. They never used the words colored or African American or freemen or black. They were, in terms of their language, colorblind. Just because the administrators of the law engaged in discriminatory practices did not violate the 14th Amendment in any way, because it's just the law that mattered, not the agents of the state who administered it. And besides that, as far as the 14th Amendment was concerned, that's not Congress which was doing the lawmaking in any case. The civil rights cases declared unconstitutional laws that Congress had passed, laws that Congress had passed to protect the free men. United States v. Harris is a ruling that said that when black citizens of states and of the United States were lynched, this did not violate the 14th Amendment, guaranteeing equal protection under the law. Why? Can anybody guess why states were not held responsible for violating that? Because do states lynch? No, private citizens lynch. And if a private citizen is lynched and the state does nothing to prevent that, according to the Supreme Court, the actions of private individuals are not something which violate mean that states have violated the 14th Amendment. Leave aside the fact that equal protection under the law does seem to me to require states to provide protection. But the court ignored that and had this very, very narrow reading that the Bill of Rights and even understanding of the words like equal protection did not require states to protect their black citizens. So, the slaughterhouse cases essentially put the 14th Amendment on the back burner for decades and decades. And I invite anybody who is an expert in the law far more than I am. I think to this day, officially, the court has never actually accepted the doctrine of incorporation. But by that, I mean that it has incrementally incorporated the Bill of Rights into state constitutions. Piecemeal, it's incorporated it. But there has never been any one overarching decision that states that, yes, the 14th Amendment entails the incorporation of the entire Bill of Rights into the state constitutions. It's been something that's only happened over a long, lengthy period of time, and it still hasn't entirely happened. All right, so bottom line of all this, the slaughterhouse cases and their aftermath, the court chose to protect power and privilege and left at the mercy of repressive actions and repressive states the freemen of the United States of America, and it was hardly a beacon of support for the weak in our country. Now we're going to take a look at another group of people who were relatively powerless. I don't know if it's recognized by the audience here, just how extensive and violent United States labor history was. I think it's been pretty much demonstrated by historians that of the democratic countries of the so-called Western world, the United States had the most serious labor strife of all, late 19th century into the mid 20th century. The issue of substantive due process is central to what happened to labor in this country. The dirty word for labor back in the late 19th and early 20th century, when it came to the government and the courts, was the injunction. Because workers, as I think all of you know, would engage in strike activity. Sometimes there was violence, sometimes there was not. The strike being one of the most effective tools that labor had, insofar as it was at all effective in terms of gaining their bargaining rights. The action of the courts in issuing injunctions meant that you could land in jail, go bankrupt as not just a labor union, but as an individual, if you violated an injunction and continued to engage in labor action when you were when you were violating the injunction. Now, aside from the injunction, labor activity and the muckraking writings also led many state governments and finally the federal government to come under pressure to pass laws to relieve the terrible working conditions that existed in those years. And among those things were things like minimum wage laws, minimum hour laws that states would pass. So let's take a look at what the courts do with that. Here's the Louisiana case in which for the first, I think it's the first time that the court actually brought up this doctrine of substantive due process. So,
John, I don't think that's correct.
what came before, Josh? Tell me.
It's widely believed the first, well, when was this case, John?
This one would have been, I think, in the 1880s or 90s.
Okay, well,
Maybe
according,
1890s.
yeah, according to Robert Bork, the first case to do this was Dred Scott.
Oh, interesting. All right. Yeah.
But there was no 14th Amendment at the time of Dred Scott. That was probably interpreting the Fifth Amendment because there was no 14th Amendment.
Because there was the due process clause in the Fifth Amendment. That's right.
Right.
Not in the 14th. Yeah.
So no, but so substantive due process began even before the 14th Amendment. In other words, because it
Right,
relied
right.
on the due process clause of the Fifth.
So let's actually explain substantive due process and its ultimate emergence. By the way, Josh, I remember that decades ago, you and I would have discussions about substantive due process. So, Josh, you spoke up. What is substantive? What is due process in the procedural due process?
It's what it says. It's procedural. It has nothing to do with
Well, it means that if you are denied of your basic rights of life, liberty, or property in a process in which the law has been followed and the law has been duly and legally, procedurally correctly enacted, then your due process rights have not been violated. If you've been for example, informed of your crime, duly charged, duly tried, whatever the laws of the land may be. In other words, if you haven't been subjected to arbitrary action, then your procedural
to trial by jury and the
yeah,
procedures.
right. Then all is fine and good, even if the outcome may stink for you. But substantive due process does what, Josh?
It basically gives carte blanche to.
Well, the theory of substantive due process is that we possess rights that are basic to our existence, which may not necessarily be spelled out, but they are essential to our living lives as free citizens. And once you adopt that position, the argument goes, a state now, once we recognize that you have those rights, a state cannot pass any laws which interfere with or violate or suppress those rights unless there is an argument, a compelling state interest argument that justifies that. Josh, is that a good way of phrasing it?
Yeah, it's
That in effect, what it does is it places the burden of proof on the state now.
right. Well, and it's been used, both in terms of protecting property, supposed, inalienable property rights, and so whether it's another case that uses this is Lochner.
Yeah,
right?
I'm gonna go to Lochner now, actually.
And another case that used it quite differently was Roe.
Right, but we're not going to Roe yet. That's a very different way, and I'm gonna first go through the.
Griswold, which then led to Roe. Yeah.
Yeah. Okay. So the Lochner case concerned bakers' working hours, and New York State had passed this law that limited the amount of hours bakers could work on a given day. And in hearing the case, the court basically took the same position it had in Allgaier, which is that there is a right to contract, that one of your essential rights as a free human being is to enter into a contract of your choice. And a contract of your choice may be, in the case of a baker, an employee of a baker, that I want to work whatever hours the employer is willing to have me work. If he has 12 hours or 15 hours available, I should be entitled to do that kind of work. And the court said, no, that's not permissible, because to have a law that says you can't work more than 10 hours. The court took the position that to tell a human being, a free human being, that they could not enter into a contract which enabled them to work more than 10 hours was illegal, was to violate an essential right. And for the state to violate that essential right, would require it to demonstrate that it had a compelling state interest under the policing powers. And the argument of the court, the majority of the opinion of the court in the Lochner case was, it's one thing to say that somebody who's engaged in, let's say, coal mining can be limited in the numbers of hours that they work because it's a dangerous job. But there's nothing dangerous about being a baker. Working for 12 hours or 14 hours is not going to cause some sort of significant individual or social harm. And therefore, the state cannot take a paternalistic position and protect you from those excessive working hours. Now, the right to enter into a contract, the right for a contract not to be violated is protected by the Constitution, but the free right to enter into any contract that you want as a basic human right is nowhere in the Constitution. And with substantive due process, the Supreme Court is inventing, and Josh, I think you said it a little while ago, it gives carte blanche. The court can discover any kind of basic right that you have and then place the presumption, the burden on the state to prove why it has a compelling interest to pass a law that violates those rights. It just opens up the court to abrogate anything it wants.
A good place to look at the origins of this particular, as it pertains to the 14th Amendment, are the dissents in the slaughterhouse cases, where one of the dissenters who writes about Adam Smith and the right to, pursue a trade as an inalienable. It's worth a look. The dissents in slaughterhouse.
And in the case of Lochner, I think the Holmes dissent is particularly compelling because what his argument is that even if you adopt the position that there are substantive due rights, you could, who's going to decide what they are and what's the compelling state interest? And essentially Holmes's argument is it should be the sovereign people through their legislative process. But to have the court, a small group, impose their own view of what your basic rights are is essentially, and this is the great line, it's it's making its decision based upon an economic theory which a large part of the country does not entertain. They're imposing their theory of how the country should be run, what the economic system should be. And Holmes is saying, let's have some judicial restraint. It's up to the sovereign people to decide those things. And, that's a position which I take as well. So it turns the courts into our sovereign, our decider, the paternalistic institution, which gets to tell us what our rights are and what laws we may or may not pass. With the injunction, the court once again took a position at odds with the popular mood of the country and imposed its own economic beliefs. The Sherman Antitrust Act had allowed the courts to issue injunctions left, right, and center, but the Clayton Act that was adopted, I think it was in 1913, the Clayton Act explicitly protected employees from having the injunction imposed, except if they were violating, safety, and if they were violating the any engaging in something which was dangerous. And the people who wrote the Clayton Act once again were very clear what they meant by it in terms of the injunction and in terms of protecting labor unions and as far as strike activity was concerned. But when the cases start coming before this court in the 1920s, the court chose to ignore the legislative history. It chose to ignore the intent of the of the Clayton Act, and it concerns secondary boycotts. there was a strike against a printing press manufacturer. There were three major printing press companies in the country. Two of them allowed unions, one of them didn't. And finally, the duplex printing came under labor. Came under labor pressure. The labor unions there struck. They organized a secondary boycott, meaning that truckers, for example, refused to deliver the duplex printing press products to customers, so on and so forth. And the printing press union was issued an injunction to cease the secondary boycott. And when they didn't, the arrest took place. They sued. They initially won. There was another appeal. It rises to the highest court, and the highest court made the following ruling: that simply to instigate a sympathetic strike, meaning a secondary strike, cannot be deemed peaceful and lawful persuasion. It is a threat to inflict damage. And essentially what they said is that the Clayton Act made no changes to the state of the courts and injunctions and strikes and secondary strikes, that the clear intent of the people who wrote the Clayton Act to prevent these injunctions was not what it was meant to be, that the injunctions could continue to be issued. And for those of you who know your court history, you'll know that this attack on labor unions and their activities under these principles was something which the courts continued even in the midst of the Great Depression, when they overruled many of the laws that were being passed by the Congress during the New Deal period, until the so-called switch in 9, and Roosevelt got a chance to ultimately bring in his own court appointees as one after the other retired or died. And what I'm going to end with on this labor note here is just simply that period from the late 1930s until the early 1970s. So we've got a 35-year period of history approximately, in which the court did in fact exercise a relatively liberal function in terms of protecting the weaker, less privileged minorities in this country. And I'm going to finish with just at least touching upon today one last case and criticizing it, carefully criticizing it, and that's Brown v. Topeka, the decision which overturned Plessy v. Ferguson and banned segregated schooling. The criticism, the background to my criticism is how the court went about it. The simplest way to go about it would have been if they had believed in the incorporation doctrine and essentially acted to look at the reasoning behind why there were segregated schools, which were clearly meant to be discriminatory. That was the purpose behind them. If they had attacked the Plessy v. Ferguson decision of separate but equal in that way, the decision would not have been interpretively weak. But what they did was something which I think was very dangerous and strictly thought through. And I'm not sure if this is the criticism Bork made of it. It really provides an opening for Brown v. Topeka to be overturned. Because what they did was the following. They said, all right, Plessy v. Ferguson says that segregated institutions didn't concern schools with Plessy v. Ferguson are okay as long as they're separate but equal. And then what the court did was it took a sociological studies that had been done. It had to do with dolls, I believe, and little children playing with dolls, which had indicated that they showed a preference for Black and white children playing with seemingly white dolls. And the experiment was meant to demonstrate that African-American children grew up with an inferiority complex, and therefore it suggested that segregated schooling had led to that inferiority complex. It immediately imposed upon the young children a sense of inferiority. Therefore, there could not be separate but equal in this circumstance, and the segregated schooling therefore could not stand. Now, to me, the problem with that type of judicial reasoning and the fact that the court can somehow invent this particular method of interpretation, which is one of the dangers of a judicial review, if they could adopt whatever method you want, is that what if a sociological study, first of all, sociological studies, and they're not hard science. I don't think that we should rely on them as a given objective proof of something, especially when it comes to something like lawmaking. Hypothetically, what if one could come up with a different study? And that's been happening. I know that there have been some figures involved in education and involved with the African American community that say, you know, having our children go to integrated schools actually creates a burdensome sense of unfairness and inferiority. And therefore, we want to have African American only schools. And what if, you know, you have a sociological study that seems to suggest that? Should we then overturn Brown v. Board of Education and say that it's okay to have segregated schooling by law?
Yeah, John, another case that did this was the Virginia Military Institute. The court ruled that it had, under the Constitution, had to be co-ed, had to allow women, that it couldn't be a male-only academy.
Right. And what was their reasoning behind that?
Let me see. I don't remember exactly, but
All right. Well, my bottom line here is that the court has developed a systematic variety or basket of rules of ways of judicial reasoning once they gained the initial power of judicial review and canceling legislative enactments, that they are, by the point that this particular class comes to an end in the early 1950s, have developed a series of doctrines which allows them to run amok, imposing their ideology and their positions on society, engaging in politics without the sovereign people having any opportunity, any realistic opportunity to undo the mischievousness of the court. The other reason why the court, leaving aside doll experiments, that the court adopted the cancellation of Plessy v. Ferguson had to do with the Cold War, that the Cold War put America into a troublesome position when it came to Jim Crow laws, and that we should get rid of Jim Crow laws in part because it made it difficult for America to protect its foreign policy interest in the struggle against the Soviet Union. And, you know, to have that type of an argument be central to an important part, an important argument being made in court reasoning and court decisions is no longer judicial behavior. It's just simply the court finding any reason it wants to do whatever it wants. They have become our sovereign authorities. All right. So any comments? Because next week we're going to be looking at abortion, contraceptives, and beyond. Alex Tillell, Brown v. Board of Education. What do you think of that decision? Was Bork right?
Fundamentally speaking, Brown v. Board of Ed is obviously wrong. I think that's the not so subtle subtext of your remarks. And look, I think also the way, but that's what we have these days, right? I mean, we've essentially said that it's okay for the court to substitute its policy preferences for that of the legislature. that's what we have. We like this. We as Americans have decided that that's the role of the court. And the price you pay is that the court's going to decide at various times those individuals, those 9 unelected political appointees, are going to make value judgments and move the social needle, right? And so, for example, one thing that Justice Warren didn't consider is that Brown had devastating impact on the lives and families of Black educators.
That's
Tens
right.
of thousands of Black educators lost their jobs and had a tremendously destructive impact on them, their families, their children's families.
And I want to
And,
add to that, historically speaking, those people were often the central stabilizing community, core community leaders of those communities. The developing African-American middle class, unintended consequences. You can always count on that in history.
Yeah, and recall, by the way, that we, as I think I mentioned this in the last right, that at this time, future Chief Justice Rehnquist is clerk to Justice Jackson. You've got just a tremendous group there. You've got he's clerk to Justice Jackson. Alex Bickle is clerk to Frankfurter at the time, and I think
Bickle,
at
by the
one
way,
point-
if I'm correct, is never conceded that the 14th Amendment was meant to be incorporate the Bill of Rights.
It's never been conceded. I think the closest we have to a pronouncement is probably Hugo Black's dissent in Adamson. But anyway, look, so segregation, I think, but Rehnquist says something like this, and he's not wrong. I mean, the reality is that the court decides in Brown that segregation is inherently bad. We don't like it. The reality is, as you point out, that the reason we don't like it is essentially purely sociological. It doesn't have basis in constitutional doctrine and any canon of interpretation. It's just that we don't want it. But the idea that the Supreme Court of the United States is going to step in, right, and effect that change, I don't think it's any stretch to say that the founders didn't have that in mind when they crafted Article 3. And I think that's the fundamental problem with Brown. And we see it reach really its high water mark, and I think some of the cases we're going to discuss next time around.
Right, high water mark in terms of liberal.
Well, it's I don't know. I high water mark. I say that I think I don't want that to be construed as a good thing. I like to consider myself a constitutional libertarian, and I think that you are too. Really, I really believe that, because I think the other subtext of what we're discussing is, we want to have strong rights, right? A woman's right to choose, for example. We want that not just to be a right, we want it to be a strong right. And the problem is that when we decide that it's the province of the judiciary to make the call on whether that is a right, then what we've done is we've actually just subjected it to a political process. And so that right is now a weak right, because it's subject to the undulating views of whoever might be on the court at any particular moment. So it's, this is the tricky thing to me is that we complain about the court being politicized, but we as a society, right, have decided that this is what we're going to use the court for, to move the social needle when we're not satisfied with what's going on at the legislative level, right? When what we could otherwise do is, right, simply just vote out the people we don't like and have a legislature doing the things that we want. But we don't live that way anymore.
No,
John, this is highly relevant to what's going on in Israel now.
right.
where
We talked about that.
The Supreme Court strikes down Knesset legislation, even though Israel, like the UK and New Zealand, does not have a written constitution that they can say they're applying in
Right.
striking laws.
I just want to throw one other thing in, but partly inspired by what Alex said, or provoked by what Alex said, which is, and here I'm getting quite utopian. If I had my way, I would try to get rid of the whole language and idea of rights to begin with. But that's another story. I don't think it's a healthy concept. So, I'm somebody who's in favor of a grant of a woman being permitted to gain an abortion when she wants, but I don't believe in a right to anything. So I just wanted to let you know that, Alex Tillell.
I firmly accept that concept. I think that, look, it's a tricky thing, right? So I do believe in a woman's right to choose, but I don't believe, and I don't think, and this is not controversial, right? There are many people on the right and the left who feel this way, and the reality is that there's no question that a right to an abortion is protected by the Constitution. It's obviously not. What might be protected by the Constitution is a woman's right to make certain choices with her doctor in a private medical context, or the right to not have the state impinge upon a woman's right to plan her family, right? But this is the tricky thing. When we start talking about fundamental rights, it has become de rigueur in this country to assume that then that question goes to the courts, and it is the courts who decide just how fundamental those rights are, and whether they should be rights at all. And so now what we've done is we've taken what we want to be a very well protected right, and we've subjected it to a judicial process that, as we've learned tonight, it's very much dependent on who happens to be sitting on that court at any given time.
Right. It's sort of, and the warning, the cautionary tale, which I think I discussed it with you privately, or maybe after people had left last week, is that be careful what you wish for, because when the Warren Court was issuing all those very, very creative rulings, my own position is don't be so joyful, because when the court becomes dominated by a different way of thinking about society, and they adopt the same methodology, you're going to be screaming bloody murder. And that's what's happened. And so much of our political discourse now centers around who's going to be, not who's going to be the president, but who's going to be the president who gets to choose the people who really rule over us. And it's a very unhealthy political development that enervates our democracy and makes us cynical about our democracy. I can't prove cause and effect, but I suspect that it might even play a role in things like voter turnout and the discuss with politicians.
Of course it does. And it actually reminds me, I don't know if this might have come up in one of your classes. It should have. It's the kind of thing that would have, but it reminds me of, there's an old story, possibly apocryphal, about Abigail Adams, that she took her kids to school, and the kids, and there was a black family, and they tried to send their kids to school, and the school wouldn't take the kids. And she marched right back to that school, and she said, guess what? You will be taking those children of color into the school, or my kids are not going to be coming to this school. And then you see how well your school gets on once everyone finds out that John Adams' kids don't go to the school anymore. And you know what happened? The school took the kids. And that's America to me. Today, what would happen is Abigail Adams would go to that family, find 7 other families, and say, hey, listen, let's get a couple plaintiffs together here, and we'll, file suit in the lower courts, and we'll work this all the way up. And, eventually we'll get up to the Supreme, and they'll announce that we have certain rights. It used to be, I think, what the founders envisioned is that, individuals would just have the courage of their convictions to affect that kind of change on the ground, whether directly or through electing people who would do it for them. And really, I think it's really no stretch to say that they are rolling in the grave today, seeing what's become of the judiciary.
Right.
What we made of it, really.
Any other guy? Is that Mussy's father or mother there? You can unmute yourself possibly. Dunst, nice to see, well, not see, but see your names there. Two of the Dunst. Rosie, good to have you back. Andrew, is that Andrew Kuehl or another Andrew? Shyness or just left it on. But anyway, yeah, next week we'll and what I hope to finish on next week is not just look at some of those cases, but also some of the proposals that have been made to rein in the galloping horse of judicial review. I'm not sanguine about them being adopted, but at least I'm going to throw out some suggestions and make the argument that they are constitutionally permissible. Not that I really care whether something's constitutionally permissible. All right.
Dr. Jacoby, Dr. Jacoby, it's Andrew Kuehl. I couldn't hit the unmute button fast enough. But,
Oh.
good to see you and great lecture. Thank you so much.
Thank
Thank
you. For coming.
Thank you, John. Be well.
Thank you, Dr. Jacoby. Next week again. I wrote you an
Okay,
email.
great. Okay, great.
Learned a lot. Thank you.
Thank you so much.
Everybody, have a wonderful night.
Thank you, Leah.
Bye, thank you.
Bye-bye.
Thank you.